The committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. Pursuant to Committee Rule 5 and Rule 11, House Rule 11, the chair may postpone further proceedings today on the question of approving any measure or matter, or adopting an amendment of which a recorded vote for the yeas and nays are ordered. Now, pursuant to notice, I call up a report containing a contempt resolution.
Mr. Chairman, I have a point of order.
May I finish? May I please finish? Thank you. Now, pursuant to notice, I call up a report containing a contempt resolution related to the 2020 census. Clerk will report the report, which has been distributed in advance.
Mr. Chairman, I have a point of order.
The gentleman is not recognized.
Well, the point of order, actually, from a parliamentary standpoint, is a privileged motion, so I have a point of order, Mr. Chairman.
What is your point of order?
My point of order is that Rule 2F of the committee rules have been violated. And the chairman has received a letter which would outline that that particular rule requires a 3-day notice, Mr. Chairman. And because the notice was put out on June 10th at 5:48, this committee's rules have been violated. Now, the chairman may be able to overrule this point of order, but I would like to clarify that if indeed this committee overrules this point of order, then indeed it would be subject to litigation by House counsel. You will require the Department of Justice to file a brief. It will be litigated because indeed this is violating the House rules that everyone here agreed to.
Thank you very much. Thank you. I'd like to address the letter the ranking member sent last night, raising a new technical argument about the committee's rule on circulating the memo for today's business meeting. Basically, he argues that the memo should have been sent last Friday instead of this past Monday. I sent a letter back to him this morning explaining my position, and I can summarize it here. In the last Congress, the committee rules used to require a memo 72 hours before a business meeting. In January, we on this committee unanimously adopted rules that changed that requirement to 3 days. As I stated when we made that change, our purpose was to make sure that our committee rules matched the House rules. The timing of our committee rule was drawn from the House rule on noticing business meetings. That rule provides that a markup cannot occur, and I quote, earlier than the 3rd calendar day before it is noticed. The House parliamentarian has interpreted this rule as including the day the notice is sent and the day the business meeting occurs. Committee staff confirmed this interpretation with the parliamentarian again yesterday. So in other words, we needed to send a notice on Monday for a markup today.
Mr. Chairman.
May I finish, please? Sure. That is exactly what we did here. That is how we have been interpreting our rules for the past 6 months. And that is now how I interpret the rule today. With that said, I understand if this rule change caused some confusion. There are slight differences in the wording of our rule and the House rule. The problem with the ranking member's interpretation is that the committee could send a memo out to members before we even notice a markup. I do not think that process makes sense, and that is not the intent of our rule. I've stated my interpretation of our rule. However, as I wrote in my letter to the ranking member this morning, if he still feels that there is any confusion whatsoever, because all of this has all been in good faith, I'd be open to further discussions to clarify or to amend our memo rule in the future. With that,
Mr. Chairman, so let me follow up on my point of order. And while I appreciate where the staff is giving you clarity from the parliamentarian in the House, this committee purposefully, with your words, took different language. And I'll read: at least 3 calendar days, excluding Saturdays, Sundays, and legal holidays, before each meeting or hearing. In your words, Mr. Chairman, the minority wanted to give more advance notice for hearing memos, so we did that. That was a quote from you. And we purposefully, in this committee, because of the importance of this committee, made a difference between the House rules. And so I would suggest respectfully, that this particular rule is indeed intentionally different. And by that, we're opening ourselves up to litigation on this particular issue, where just postponing by 1 day would have made us in compliance. And I respectfully yield back.
I have explained my interpretation, and I've offered to work with the ranking member going forward to resolve any remaining confusion. I'd point out that our rule also includes a separate independent provision allowing the committee to go forward in unusual circumstances. The ranking member's letter last night, for the first time raising a novel technical issue with our rules that has never been raised over the past 6 months, certainly would qualify under that provision. I would also remind my colleagues that they did not object when they were in charge. For example, in 2016, Chairman Chaffetz summoned FBI Director Comey before our committee with less than 48 hours' notice. The only unusual circumstance in that case was that he did not like the fact that no criminal charges were brought against Hillary Clinton. The bigger point here is that members were aware that we were going to vote on contempt this week. It was the subject of many letters back and forth between the committee and the administration, and the ranking member was copied on all of our letters. I've explained my position, and I have offered to work in good faith with the ranking member going forward. Now let's proceed.
Mr. Chairman, could I just comment?
I recognize the gentleman.
I thank the gentleman. I appreciate what you just said. The bottom line is exactly what the gentleman from North Carolina said earlier. The notice is legally defective. It will, in fact, be litigated. The remedy was real simple. The remedy was real simple. Just wait before you do this contempt vote. But understand, you guys can't do that because you are so concerned the Supreme Court's going to rule on this that you got to get it done before that happens. We know that. Members of this committee have said they're trying to influence the court. So it was real simple. We, as the gentleman from North Carolina pointed out, we specifically wanted this notice for 3 full days, 72 hours, because when you're getting ready for something as important as holding a Secretary of Commerce and the Attorney General of the United States in contempt, for goodness sake, you want every minute you can to be ready for that debate. That's what's at stake here. So the notice is in fact effective. It will in fact be litigated. The remedy is real simple, postpone the hearing, but you weren't willing to do that because there's a Supreme Court case coming any day now. And that's the problem. And that's why the gentleman's point of order is exactly right. We should postpone this hearing on this particular, we can have the markup on the other issues, not on this one. With that, I yield back.
Thank you very much. Without objection, the amendment is considered read and will serve as a base text for purposes of amendment. I now recognize.
No. Has the chair ruled on?
I've ruled it. I've already ruled.
I appeal the ruling of the chair.
All those in favor of the appeal signify by saying aye. Aye. All those opposed, no. No.
Ask for a roll call vote, Mr. Chairman.
Roll call. Clerk will call the roll.
Mr. Cummings?
No.
Mr. Cummings votes no. Ms. Maloney? No. Ms. Maloney votes no. Ms. Norton? Mr. Clay? Mr. Lynch? No. Mr. Lynch votes no. Mr. Cooper?
No.
Mr. Cooper votes no. Mr. Connolly?
Nay.
Mr. Connolly votes no. Mr. Krishnamurthy? No. Mr. Krishnamurthy votes no. Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Ruda? No. Mr. Ruda votes no. Ms. Hill? No. Ms. Hill votes no. Ms. Wasserman Schultz? Ms. Wasserman Schultz votes no. Mr. Sarbanes? Mr. Sarbanes votes no. Mr. Welch? Ms. Spear? Ms. Kelly? Ms. Kelly votes no. Mr. DeSaulnier? Ms. Lawrence?
No.
Ms. Lawrence votes no. Ms. Plaskett? Mr. Khanna? Mr. Khanna votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Ocasio-Cortez? Ms. Presley? Ms. Presley votes no. Ms. Tlaib? Ms. Tlaib votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Ms. Fox? Mr. Massey?
Yes.
Mr. Massey votes yes. Mr. Meadows?
Yes.
Mr. Meadows votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Grothman? Mr. Comer? Mr. Comer votes yes. Mr. Cloud? Mr. Gibbs? Mr. Gibbs votes yes. Mr. Higgins? Mr. Higgins votes yes. Mr. Norman? Mr. Norman votes yes. Mr. Roy? Mr. Roy votes yes. Ms. Miller? Ms. Miller votes yes. Mr. Green? Mr. Armstrong? Mr. Armstrong votes yes. Mr. Stubbe? Mr. Stubbe votes yes.
How is Mr. Grothman recorded?
I'd like to be recorded.
Mr. Grothman is not recorded.
How is Ms. Fox recorded?
Ms. Fox is not recorded.
Is Mr. No, you go ahead. I'm sorry.
Ms. Fox votes yes.
How's Mr. DeSaulnier, please?
Mr. DeSaulnier is not recorded. Mr. DeSaulnier votes no.
How is Ms. Hill recorded?
Ms. Hill is recorded as no.
How's Ms. Norton recorded?
Ms. Norton is not recorded.
We get everybody.
Ms. Norton votes no.
We get everybody.
I just want to confirm that I was recorded.
Mr. Grothman,
Yes, was
you're
I?
recorded as yes.
Yeah.
How's Ms. Ocasio-Cortez?
Ms. Ocasio-Cortez is not recorded. Ms. Ocasio-Cortez votes no.
If no one else is voting, the clerk will give us the tally, please.
On this vote, we have 15 yeas and 20 noes.
Thank you very much. The motion is not agreed to. Let me just say this. I will work to clarify that rule. I now recognize myself for an opening statement. Today, we are considering a resolution and report that would recommend holding Attorney General William Barr and Secretary of Commerce Wilbur Ross in contempt of the Congress of the United States of America. They both refused to comply with duly authorized subpoenas issued by this committee that require them to produce documents relating to the addition of the citizenship question to the 2020 census against the advice of experts at the Census Bureau. What we have learned so far in this investigation is quite disturbing. Secretary Ross testified that he added the citizenship question, and I quote, solely, end of quote, in response to a request from the Department of Justice in December 2017 to help enforce the Voting Rights Act. We now know that this was a pretext. We've obtained evidence showing that Secretary Ross was aggressively pressing his staff to add the citizenship questions months before any request from the Justice Department in the spring of 2017. And he was doing it at the urging of the White House. Doing it at the urging of the White House. We also now have evidence that President Trump's advisors began discussing citizenship questions long before the President took office. After his inauguration, the President discussed the idea with his top White House aides, Reince Priebus and Steve Bannon, who in turn pressed it with Secretary Ross. And although we have limited information about this scheme, we've been blocked from fully determining the real reason the administration sought to add the citizenship question. That is because the Department of Justice and the Department of Commerce have refused to turn over key documents requested by this committee. For these reasons, on April 2nd, 2019, more than 2 months ago, this committee voted on a bipartisan basis to authorize subpoenas to Attorney General Barr and Secretary Ross for key documents regarding their efforts to add the citizenship question. During that time, we've tried repeatedly to resolve this impasse. As an accommodation, we narrowed the scope of the subpoenas